Companies Act, Section 302, Tribunal's power to order the dissolution of a company upon completion of winding up. Section 302 of the Companies Act, 2013, deals with the final stage in the life cycle of a company that is undergoing winding up by the National Company Law Tribunal, NCLT, namely, the dissolution of the company. This provision specifies the conditions, process, and responsibilities relating to the formal dissolution once all affairs of the company have been fully settled and its existence is no longer required. 1. Application for dissolution after completion of winding up. Once the affairs of the company have been completely wound up, meaning all assets have been realized, all debts and liabilities settled, remaining surplus, if any, distributed to the entitled stakeholders, and all records finalized by the company liquidator. The company liquidator is required to file an application before the tribunal seeking an order for the dissolution of the company. This application signifies that the liquidation process is concluded and that the entity has no further business to conduct or obligations to fulfill. 2. Tribunal's power to pass a dissolution order. The tribunal may proceed to dissolve the company in two situations. A. Based on application by the company liquidator. After examining the application and being satisfied that the winding up process is complete, there are no outstanding issues requiring further adjudication or supervision, the tribunal may pass an order declaring the company dissolved. B. On tribunal's own motion. Even in the absence of an application by the liquidator, if the tribunal is of the opinion that it is just and reasonable based on the facts and circumstances of the case that the company should be dissolved, the tribunal may, suo motu, make an order for dissolution. Effect of the order. The order shall take effect from the date it is passed. From that date, the company is deemed to be legally dissolved, i.e., it ceases to exist as a legal entity. 3. Communication of the dissolution order to the registrar. To ensure that the company's legal dissolution is reflected in official records, the Act prescribes the following steps within 30 days from the date the tribunal passes the dissolution order. A. Duty of the tribunal. The tribunal shall forward a copy of the dissolution order to the Registrar of Companies, ROC. The registrar, upon receipt, shall record a minute in the official register maintained for the company. This minute serves as formal documentation of the company's dissolution. B. Duty of the company liquidator. In addition to the tribunal shall also direct the company liquidator to send a copy of the same dissolution order to the registrar. The registrar, upon receipt from the liquidator, shall likewise record the dissolution in the register by entering a corresponding minute. This dual reporting mechanism by the tribunal and the liquidator is designed to ensure that the dissolution is accurately captured and irrefutably reflected in the official corporate registry, thus closing the company's life cycle in the public domain. Key objectives of Section 302. To formally conclude the existence of a company after liquidation. To ensure transparency and public record of dissolution through proper registration. To provide the tribunal with flexibility to act on the liquidator's report, or suo motu issue a dissolution order, when warranted. To prevent administrative lapses through mandatory communication of dissolution to the registrar. For more details, contact us.